Hi, I'm Marilyn Golden, Senior Policy Analyst with the Disability Rights, Education, and Defense Fund, a leading national law and policy center on disability civil rights. Our hearts go out to the witnesses and other individuals supporting the law who are dealing, them and their families who are dealing directly with dying. At the same time, there are many very serious problems with this bill. And the ones I want to talk about today are of a judiciary nature, since that's where we are. I want to address, first of all, the lack of genuine safeguards, which can result in abuse and deadly mistakes. 2, very poor oversight, which manages to ignore abuse and mistakes. And 3rd, opposition by my own community, the disability community. First, the supposed safeguards of this bill are grossly insufficient to protect anyone from harm for at least these reasons. Now, some of this has been addressed. I'll just try to say things that haven't been said already. 6 months to live, quote unquote, is intended to keep everybody else safe. But in fact, misdiagnosis and incorrect prognosis, very common in medicine, has deadly consequences if assisted suicide is legal. Let me give you just one of multiple examples from my community, the disability community. John Norton was diagnosed with ALS at age 18 and given 3 to 5 years to live. 6 years later, the progression of his disease suddenly stopped, and he is alive today at age 77 with a wife, children, and retired from a successful career. He stated that if assisted suicide had been legal at the time, he would have used it, but is so happy to be alive. This is of particular concern to the disability community, which includes many people like John Norton, who've outlived terminal diagnoses for years and even decades. The question we ask is, how many John Nortons will we have to sacrifice as collateral damage to legalize assisted suicide? The second safeguard problem, doctor shopping gets around any of the hollow safeguards in this bill. That's when, if you ask for lethal drugs and your doctor says, no, you don't qualify, you or your family finds another doctor who will say yes. That's what happened to Oregonian Kate Cheney, age 85. Although a psychiatrist concluded she had too much dementia to make a sound decision, and a psychologist acknowledged her daughter was pressuring her, she was approved for the lethal drugs that caused her death. This does not sound like compliance with the Oregon law. It's important to know that Compassionate Choices, known earlier in its existence as the Hemlock Society, facilitates the overwhelming majority of reported Oregon deaths in some way. They can refer you to a doctor if yours says no. Third safeguard problem, outside pressures that distort patient choice, often from family, but not always, whether financial or emotional, can get around any safeguard and lead to abuse. Let's look at just one aspect of this multifaceted problem of outside pressures. Let's look at economic factors. 2 examples. First, of economic pressure. Linda Fleming, first to use the Washington state law, was divorced, had financial problems, was unable to work due to a disability, and was forced to declare bankruptcy before she took her life using lethal drugs. Yet the director of Compassionate Choices Washington said that her situation represented, quote, none of the red flags that might give his group pause in supporting her request for death. Yet proponents tell us that financial pressures have never played a role. Second, financial abuse. Thomas Middleton, also diagnosed with ALS, moved into the home of Tammy Sawyer and died by assisted suicide later that month. Middleton had named Tammy Sawyer his estate trustee and put his home in her trust. 2 days after he died, Sawyer listed the property and deposited $90,000 into her account. Tammy Sawyer, it took a federal investigation into real estate fraud to expose this abuse. Tammy Sawyer was indicted for first-degree criminal mistreatment and first-degree aggravated theft, partly over Thomas Middleton. But the Oregon agency responsible for the assisted suicide law never even noticed. More about that in a couple of minutes. The fourth safeguard problem, danger for people with depression and other mental illness. Undiagnosed depression and fear underlies nearly all requests for assisted suicide, like any suicide request. And for that reason, it poses extraordinary danger to people with mental illness and depression, raising another big concern for the disability community. Doctors need to recognize this because most of the time, the depression can be treated, but where assisted suicide is legalized, it remains undiagnosed, and the treatment consists of a lethal prescription. Michael Freeland, for example, had a 43-year history of acute depression and suicide attempts, but got lethal drugs in Oregon. How could this have happened? When he later, by accident, found more thorough doctors who rendered high-quality medical care and got him social services, his desire for death vanished. But doctors are often unable to diagnose depression, and when psychiatric assessments happen, they are usually pro forma, because a doctor who thinks her patient should receive lethal drugs can herself shop for a psychologist who will make a finding consistent with that view. And lastly, in getting around safeguards, good faith, quote unquote, good faith. The bill protects anyone from criminal or even civil liability, including doctors, if they act in, quote, good faith. It is virtually impossible to disprove an allegation of one's own good faith, making all other safeguards effectively unenforceable. Even more alarming, for all other medical procedures, practitioners are liable under a much stronger standard, negligence. But even if negligent, practitioners of assisted suicide will not be found violating the law as long as they practice in good faith. Moving on to my next category, the Oregon model, closely copied by this bill, is characterized by a lack of oversight, of monitoring, and by secrecy, not transparency. We actually don't know what's happening under the Oregon law. The minimal statistical data derived by asking prescribing doctors a few questions looks fine on the surface, but this data is not thorough in reflecting what's happening. It's not what it shows, it's what the data fails to show. There's no investigation for abuse. There's not even a way to report abuse. The data shows no abuses because the system is set up not to find them. Oregon readily admits they have no funding nor authority to investigate anything. It's that admission is in a number of their annual reports. SB 28 has the same system. We've heard about doctors' falsification of the death certificates, so I'll move past that point and just say that in this context, any abuses that come to light must be just the tip of the iceberg. But the proponents state flatly that there have been no abuses, no prescriptions due to outside pressure, no mistakes. What about Michael Freeland? What about Kate Cheney? What about Linda Fleming? What about Thomas Middleton? All of whom's circumstances I've described. Third, there is considerable opposition.
I think you're going to have to speed it up. You're about at 20 minutes, so if you could just...
Okay. I just wanted to point out that there's a lot of opposition by the disability community with the numerous organizations. I've given several reasons why. I want to give you one more. Potential abuse around communication. This bill explicitly makes it possible for someone else to speak to the patient if they're familiar with their, quote, manner of communication. This is frightening to somebody with a significant speech disability in our constituency that makes it hard for others to understand them. The history of abuse to people with disabilities show how guardians act outside our interests very often. An abusive caregiver, too, can misinterpret what we're saying and our oral and even our written wishes. So just to conclude, our assisted suicide is bad medicine for California. Thank you for opposing this risky, reckless bill. Thank you.
Thank you very much. Those who are in opposition to the bill, if you would step forward again, name, affiliation, and position, please.
Janus Norman with the California Medical Association. Our list of concerns is listed in the analysis. We appreciate the work of staff.
Thank you, sir.
I'd like to share with the ARC and United Cerebral Palsy California Collaboration, a coalition of people with developmental disabilities and their families, friends, and service providers, and we oppose the bill.
Thank you.
Henry Contreras with the California Foundation for Independent Living Centers. We represent 21 independent living centers statewide, and we oppose the bill.
Thank you.
Madam Chair and members, Nathan Mansky representing the Alliance of Catholic Healthcare in opposition to the bill. Thank you.
Thank you.
Madam Chair and members, Bob Giubati with the State Council on Developmental Disability as well. The State Council does not have a formal opposed position. We do have some concerns, and we're watching this bill very closely. Thank you.
Thank you.
Barbara Glazer on behalf of the California Hospital Association. We very much appreciate that the authors and committee have taken significant amendments at CHA's suggestion. We look forward to continuing our work.
Thank you.
Brian Johnston, former Commissioner on Aging for the state of California, served on the Board of Examiners of Nursing Homes for California and on the National Legal Center for the Medically Dependent and Disabled. Very concerned that the medically dependent and the emotionally vulnerable are at immediate risk wherever this has become law. I urge you to oppose this bill.
Thank you.
Hi, I'm Lori Hyrup from Sacramento, California. I would just like to say that I'm 59 years old. I've been using a wheelchair since I was 5. I resent the idea that this is death with dignity, as though my life is not dignified. I have 2 children. I have 4 grandchildren. I've had several terminal diagnoses throughout my life, including ALS, similar to Stephen Hawking's and the others that are still around. And I just want to say that I totally oppose this law, and I think we are really looking at opening up a Pandora's box. And in terms of safeguards, Oregon right now is already changing one of their main rules by another piece of legislation, which only goes to prove that there's nothing that can stop us from doing the same here. And I think someone that was was in support of it said if you don't support it, or if you do support it, she's going to move here. If you do support it, I'm moving. Thank you.
All right, tit for tat. Thank you very much.
My name is Yolanda Canuck, and I'm representing Concerned Women for America, and we sent a letter, and we strongly oppose. On a personal note, one time I got a prescription, and it was the wrong medication. So, and then the other thing is that this is like having a loaded gun in the house without a safety lock. Kids could get a hold of it. Thank you.
Thank you.
Andrew Porter, a retired physicist, member of Not Dead Yet. Safeguards are utterly unenforceable, which is why the disabled oppose this bill.
Thank you, sir.
My name is Susan Henry. I'm a social worker in the Sacramento area. I have about 5 years of hospice experience, and in my experience, patients pass in a comfortable, peaceful manner 100% of the time on hospice when they were being monitored and sticking to their pain management regimen. I strongly oppose this bill. I feel it will cause disastrous effects on our society. Thank you.
Thank you.
My name is Valerie Johnston, and I'm from Sacramento. I strongly oppose this bill because I've always admired doctors that will not give a lethal medicine to their patients, even when asked, and this totally turns it upside down, and it's bad for our society. Thank you.
Thank you.
Thank you. My name is Margaret Dorr, and I'm an attorney from Washington State, where assisted suicide is legal. I've given each of the members a memo. The language does not say what the speakers this morning said. It says it is not a sure choice. Just one example, and then I'll let other people talk. And I'd urge you to look at the language about the death certificate. You have an amendment that says if someone uses the lethal dose, the death must be reported as natural. Well, what if they used it when they were drunk and didn't consent? What if they used it and somehow it was given to them against their will? It still has to be reported as a natural death instead of murder. Thank you very much.
Thank you.
I'm Georgia Hyrup. My son-in-law committed suicide, and he was in a lot of pain and everything. And you know what the problem was? Us that were left behind. The guilt, we didn't know where we failed him. And my mother died of colon cancer, and they gave her a year to live, and she lived for 4.5 years. And the hospice called me, and she said, "Thank you for being so kind to your mom." I said, "What?" She said, "The senior abuse is so bad. I had never heard of it before. I oppose this bill."
Thank you, ma'am.
My name is Wynette Sills. We have heard many heart-wrenching personal stories today, yet suicide is not the answer to our problems. Just in recent news, there are breakthroughs showing cures for diagnoses similar to Brittany's. And also, in the news said that the Oregon is now considering expanding their assisted suicide to include diagnosis up to 1 year of life remaining. And so for all of these reasons, I urge everyone in this room to reject suicide, and for you senators to please vote against SB 128. Thank you.
Thank you.
My name is Ralph Merletti. I'm from the Fruit Ridge area of Sacramento County, South Sacramento. I am a senior citizen. I am 69 years of age, and I want to live as long as I can. Please don't pressure the elderly or anybody else. Therefore, I strongly oppose this bill.
Thank you, sir. We hope you live a good, full, long life.
Good afternoon, Senator Palacios with the California Catholic Conference. We ask that rather than support a right to die, let us support a right to care for each other, for every person, particularly those who are seriously or terminally ill, in ways that bring meaning, joy, and love and life. Only in this way will people die with dignity, and only in this way will we live with dignity. Thank you.
Thank you.
My name is Mike Hodis. I'm from San Francisco. I'm here in honor of my wife, who had progressive MS and who was euthanized in a local San Francisco hospital. I have been now for 2 years trying to get some assistance legal to deal with that. I don't see how in any way this bill will help those kind of people who, under the guise of comfort care, are euthanized by hospitals. This will make it easier for them to do.
Thank you, sir.
Nina Ray, Roseville. Just moved back to California. I was born in California. I lived in Oregon for 40 years. Don't make me live under this legal euthanasia again. I didn't like living under that threat. Yes, a threat, and it is a threat. You don't know what it's like to live under that until you've done it yourself. And by the way, people are very afraid of hospitals already as it is, and you're going to make it worse. You're going to cause more mental problems in the public. Thank you.
Thank you.
Woodrow Ray, Roseville. I oppose this bill. Passage of the California bill will promote rationing of end-of-life health care medications in lieu of a lethal drug prescription. That's currently the case in Oregon. Can we expect that health insurance and government health programs will pay for higher costs of ethical care, or use this law to cut costs? I think we all know the answer.
Thank you. Again, if we could, name, affiliation, and position very quickly, if we could.
Justin Harford, Disability Community Organizer, representing Freed Center for Independent Living of Grass Valley, California. Freed Center has officially, formally voted to oppose the legalization of assisted suicide. I personally oppose it as well. And we have up to 20 years in Oregon and 40 years in the Netherlands to show how these laws don't work well.
Thank you, sir.
My name is Kathy Hamlin. I'm with the Patients' Rights Council, and I strongly oppose this bill.
Thank you, ma'am.
I'm Reverend Olga Herman, and I strongly oppose this bill as well. We've been promised these same safeguards with abortion. 57 million children later, I minister to women all the time, up to 8 abortions.
Excuse me. We're on a different subject, please.
Okay,
You're
right,
opposed
right.
to this bill?
I am opposed to this bill, and you know what? God said, I have set before you this day life and death. Choose life so that you and your children will live, and that's his word.
Thank you.
Cameron Snow, resident of Sacramento, on behalf of myself and my wife who suffers chronic pain from a debilitating injury, and on behalf of everyone else who's had to fight insurance companies because healthcare is too expensive, I oppose this bill.
Thank you, sir.
Danielle Cullum, Capital Resource Institute, and we oppose this bill. Thank you.
Thank you.
My name is Andrew Rivas, and I'm Director of Government and Community Relations for the Archdiocese of Los Angeles, here to request that you oppose the bill. Thank you.
Thank you, sir.
My name is Hannah Kaysen. I am a certified labor doula. I assist women in giving birth. I am from Portland, Oregon, and I do oppose this bill.
Thank you.
My name is Jonathan Keller with California Family Council, friend of many people in Senator Vidak's district down in the Central Valley, and we respectfully ask that you consider all the facts and that you oppose this bill.
Thank you.
Michael Toe with Providence Health and Services in opposition to the bill.
Thank you.
I'm a human being. I'd like to remind you, you're not God's. God is watching. God will judge.
Thank you, sir. Anyone else in opposition to the bill? All right, now is the time for questions. I'm going to start. I know Senator Hertzberg had questions. We'll proceed in that fashion. To the opponents, I have a couple questions. I want to start off by making full disclosure. I'm a principal co-author of this bill, and I'm doing this on behalf of my mother, who asked two things at the end of her life. She was dying of leukemia. She asked that she not die alone, and that she asked that she die with her dignity. And for the 27 years since that time, I have been committed to the notion that I believe people do have that right at the end of their lives. And so what I'd like to do is focus my couple questions on our representative of the oncology group and the others. In talking about concerns of abuse, and I think in particular, I'm very interested in making sure that there is no abuse with this law, but I don't think that we ignore the right of people at the end of their lives to find a way to die with their dignity as they see fit. But I am interested in things that we can do to protect it. I am particularly concerned about the notion that seniors are going to be coerced. And in the discussion by our attorney representative here, I'm struck by the fact that in your argument, you made no reference to the fact that these people had been told that they were terminally ill. Age, hopefully, is not a terminal illness, although I guess you could argue that it is, but that it doesn't necessarily mean that you're within 6 months of your death. I have a mother-in-law who last week turned 101 years old, still in relatively good health, and no one's pressuring her into doing anything, nor could they, because she doesn't have any diagnosis that she is within 6 months of her death. So what I would appreciate is in your argument that you include why, with a diagnosis from a physician, and all the safeguards, there has to be 15 days in addition to that diagnosis before someone can request medication, and the variety of protections, that you feel that this is a situation where anyone who is elderly is at risk. Could you explain why that is? Or why you take that position?
Yes, I can answer your question, I believe. Good. And I also believe that Ms. Golden has something to add. So my direct response to you is that I believe that even if we focus on someone with a terminal diagnosis, which I will concede that my own personal belief about the accuracy of diagnoses and prognoses is more an art than a science, is going to operate within the milieu that this patient is in. And if that patient is...
What does that mean? I'm sorry.
That means that we're not talking about some hypothetical perfect scenario. We're talking about real-life scenarios, Senator, in which we have to take, from my experience, the reality that people are living in a circumstance in which medical care is increasingly expensive. They may be already feeling dependent, and the suggestion as, you know, mom, you know, dad, you know, brother, you have this option available. In fact, when somebody is vulnerable, is going to not be a autonomous choice of this individual, but is rather going to be a choice of someone who feels burdened to accept the suggestion. And that's what the real problem of coercion is.
Except that what we've heard from the witnesses who are here today, that there was no coercion because they actually had to go through a process. And that's my problem here, is that that I'm trying to find a way that we can protect reasonable concerns. And there is nothing perfect, but when you're watching somebody die and you know they're dying, they're dying. This isn't a misdiagnosis. And as I understand it, most people, and we heard testimony from this young lady here who has 4 children from 11 years old and under, she doesn't want to die. She wants to live. But you know, we don't all get to make that choice. And we see people, we heard someone testify, they've had cancer 3 times, and they know if they get it again, that is a terminal diagnosis, and they want the right to make that decision. You're creating assumptions here that make it difficult to try to find the protection. You're making an assumption that I think is false and thus ineffective for your position, because there are protections here. Age is not a death sentence, and yet you are assuming that it is. This is a diagnosis, if I'm not mistaken, that could be correct, could be incorrect. If you're feeling swell, I don't think people are going to want to take any life-ending medication. We're talking about the fact that people are feeling the pain, the lack of dignity. This is all, and I think the oncologist, certainly you can measure this, and you do measure this. The notion of improving palliative care, great idea. The notion that we make all the tools available to people who are at end of life, I think is a wonderful idea, and I think we all support that. What I hear from the people who support this measure is they are asking for an additional tool that only they are able to implement. And I think, and I think that if you don't want to go about your death in that fashion, that's your choice. But for those people who are in that excruciating pain, they want to make that choice. I want to make sure they have that right. But I also want to protect, as you're talking about, in instances where there may be coercion. And would you tell me why the procedures that they are introducing are not effective in that situation? You've named 4 people. There have been 1,700, I believe, who in Oregon have taken their own lives. You've listed 4, and a couple of them actually didn't take their own lives. So I think what we need to do is address the specifics here. If philosophically you're opposed to that issue, that is your right, and if my colleagues are philosophically opposed, that's one thing. But from my perspective, and I would like to suggest from the perspective of others in this room who believe that end-of-life decisions do belong to the individual and that they should be able to have aid in ending their lives under these excruciating circumstances, I want to make sure that we are protecting them and others who may not be at that point in their lives. So, Senator, I know you wanted to
Excuse me, Madam Chair. I would like to just add that with respect to the specific cases that were referred to, the specific individuals, we also have information with the claim and the response that it's far more complicated in all cases as to those that were cited. So,
well, then perhaps we could all see those rather than get into a debate about that, because I know.
And if I could just comment on directly to your question, I don't think you did get a good response to the testimony that focused on the elderly, the elderly, the elderly. Our bill does not go to anyone who is declining because of age-related decline. Our bill is specific that you cannot exercise the rights established in this law based on age or disability. So the fact that you're getting older and you may be in a care facility, or the fact that you've lived lifelong or at some point in your life with a disability, that you're not eligible under this. The protections for people who have a terminal disease and may also be elderly or living with a disability, you have 2 separate physicians who part of their training is to determine not only the diagnosis and prognosis of the patient, but physicians who deal with end-of-life issues are also trained in, as course and conduct of their training and profession, making evaluations of decision-making capacity. One of the improvements in our bill is a requirement for a terminally ill patient to have a private consultation with the physician when making that request, so that there's not somebody else in the room who might be exercising coercion. And so that's a factor. And again, I believe the Oregon record is a very strong record of the built-in safeguards protecting against abuse or coercion. And again, we have to evaluate as legislators a balance between a public policy good for people living with a terminal illness and the compelling testimony we've heard today, and balance that with appropriate protective safeguards that do protect against coercion. And if it's shown or proven, we have remedies in there that result in felony prosecution. And that nobody is immune from that in the event of proof of coercion.
Yes.
With 17 years of evidence and data, there has not been a lawsuit that has been brought forward. There is, with respect to coercion, this is not an easy process. This is not something that is just done quickly without any thought. In addition to the two physicians that need to speak to the diagnosis, there's a waiting period, there are witnesses, the private consultation that
40% haven't used it.
And the requirement that these discussions, in case there's a language issue, must be in the language of the person that makes the request, and the fact that ultimately we have made this coercion a felony. So we feel that there are tremendous protections here, and it's not a process that just can be done helter-skelter.
Thank you. And I do have a question. There was something that you had stated that I think might be worth exploring. Again, if it's a philosophical dispute, then we can disagree in philosophy. I'm looking at hold on. I'm going to give you a chance to speak. If there is a question about how we can assure that these concerns are met, I think there have been some very strong, as you just articulated, protections. But I'd like to ask you about the oversight mechanism. Could you provide me with a suggestion on an oversight mechanism that you believe would be more protective than what we've got, to ensure that there is compliance with the requirements of the bill and that all the safeguards are adhered to?
I'd like to also address the elder abuse risk, if I may.
All right, very briefly.
Well, the problem is that there's so much to say. I'm not padding it. It's just that there's many more cases of abuse. We can send you, I just didn't have a chance to talk about them. 6 months to live isn't dying, and we have evidence that people would want to take their lives earlier. Some doctors said, let's fight the disease, and they're here 15 years later. So it's not only for people in the throes of death, but most important about elder abuse is that where assisted suicide is legal under this system, an heir, someone who stands to inherit, or an abusive caregiver is allowed to steer the person towards assisted suicide, witness their request, as was said, pick up the lethal dose, and in the end...
They can't pick up the legal dose, if I'm not mistaken. But look, there are these protections. I understand. Are you saying that these protections cannot protect against coercion? The two separate physicians, an independent conversation with the individual are not protections?
The individual leaves the room with the doctor and goes right back to their coercive family, who is going to say, what did you say to the doctor? And if there's no lethal drugs, which they thought the person was requesting, they've said to the doctor, no, it was because of coercion. They have to go right back to the family member. I mean, I think there's other areas in law that, understand that coercion is not resolved by getting one, you sort of talk with the doctor in a room. I mean,
Again,
it's a Band-Aid.
You're ignoring the fact that you've gotten a diagnosis of a terminal illness here. Okay, so, but let me go on. There are other people who have questions, so let me just ask this. Again, I'm looking for a constructive way to help tighten this up so that there is an oversight mechanism. What would you suggest to create an additional oversight mechanism to ensure that there is compliance with these fairly stringent requirements in this legislation.
Well, I wish we could have the time to explain why we don't think they're stringent, and we talked a lot about how the safeguards can be gotten around. But anyway, we just notice, I mean, we've said this, you know, in many states, proponents have never fashioned stronger safeguards, but, you know, there's no way to report abuse. There's no investigation of abuse. The state doesn't talk to doctors who said no to find out why, only those who said yes. They don't talk to families. The state of Oregon has acknowledged destroying its underlying data before they publish each annual statistical report.
All right.
So there's a lot of secrecy and lack of investigation.
Thank you. So would you respond to that? And then Senator Hertzberg.